This episode is brought to you by Charles Schwab. Decisions made in Washington affect your portfolio every day. But what policy changes should investors be watching? Washington Wise is an original podcast for investors from Charles Schwab. This podcast unpacks the stories making news in Washington and how they may affect your finances and portfolio. Listen at schwab.com/WashingtonWise.
Mifepristone is a tiny pill with a big reach.
I read things about medication abortion all the time, and I think, oh, wow, has no one ever looked at what these pills really are? So they're the size of normal pills. Mifepristone is taken in one dose. It's one pill.
Rachel Rebouché is the dean of the Temple University Beasley School of Law. She spent a lot of time explaining what mifepristone is and how medication abortions work. Medication abortions take place during the first 11 weeks of pregnancy, and they involve two drugs. One of those drugs is mifepristone.
So in 2020, Guttmacher Institute found that over 50% of people who end pregnancies in the U.S. use medication abortion. And that number has been going up over the last 20 years since it was approved in 2000. There's reason to think it's going up much more dramatically now.
But that could be coming to a sudden halt soon. Last week, a federal judge in Texas refuted the Food and Drug Administration's approval of mifepristone, issuing an injunction that would suspend that approval nationwide, even in states where abortion isn't banned. That's despite the fact that more than 100 studies over 30 years say the drug is safe. The FDA has evaluated it multiple times. It even approved a generic version as recently as 2019.
It's whiplash to read the opinion because you think, this opinion is so certain of mifepristone's dangerousness and riskiness when that's just not what the evidence says.
This week, the Justice Department appealed the ruling and asked the Fifth Circuit Court of Appeals to put the order on hold as the appeal moves through the courts. So far, the Fifth Circuit hasn't responded, and that means that tomorrow, Friday, FDA approval for mifepristone could be suspended for the first time in 23 years.
It's stunning for people who study abortion law and reproductive health, but it's also stunning for people who study healthcare and food and drug law. Congress entrusts an agency to be the expert and rely on evidence, and that agency does so within its statutory authority, but then is told it's wrong, and the evidence it reviewed and relied on is wrong through the decision of one court, without expertise in food and drug law, then where do you draw the line of what drugs are subject to challenge and what drugs are not?
Today on the show, the future of abortion pills and what it means for our ability to approve any drug, anywhere. I'm Mary C. Curtis, in for Mary Harris. You're listening to What Next? Stick around.
This episode is brought to you by Charles Schwab. Decisions made in Washington affect your portfolio every day. But what policy changes should investors be watching? Listen to Washington Wise, an original podcast for investors from Charles Schwab, to hear the stories making news right now. Hosted by Mike Townsend, Charles Schwab's managing director for legislative and regulatory affairs, Washington Wise takes a nonpartisan look at the stories that matter most to investors. Tune in to learn about the policy initiatives for retirement savings, taxes, and trade. Hear about inflation fears, the Federal Reserve, and how regulatory developments can affect companies, sectors, and even the entire market. Mike and his guests offer their perspective on how policy changes could affect what you do with your portfolio. Download the latest episode and follow at schwab.com/WashingtonWise or wherever you're listening right now. This podcast is brought to you by Progressive Insurance. Most of you hearing my voice right now are probably multitasking. Yep, even while you're listening, you are probably driving, cleaning, exercising, maybe grocery shopping. But if you're not in some kind of moving vehicle, there is something else you could be doing right now. Getting an auto quote from Progressive Insurance. It's easy and you can save money by doing it right from your phone. Drivers who save by switching to Progressive save nearly $700 on average, and auto customers qualify for an average of 7 discounts. Discounts for having multiple vehicles on your policy, being a homeowner, and more. So just like your favorite podcast, Progressive will be with you 24/7, 365 days a year, so you're protected no matter what. Multitask right now. Quote your car insurance at Progressive.com to join over 29 million drivers who trust Progressive. Progressive Casualty Insurance Company and Affiliates. National average 12-month savings of $698 by new customers surveyed who saved with Progressive between June 2021 and May 2022. Potential savings will vary. Discounts are not available in all states and situations.
This ruling came from a judge, Matthew Kismarek. What was his reasoning for taking such a huge step on mifepristone?
So his argument is that the FDA acted improperly because it misinterpreted a piece of the statute called Subpart H, a statute that set out the process for accelerated review of drugs. He mischaracterizes in some ways what Subpart H was really intended to do, and he argues that that process under that statute should have only been used to approve drugs that treat illnesses, and that pregnancy is not an illness. Now, that has a lot of common sense value. Most people don't think of pregnancy as an illness, but the FDA for a very long time has thought about any number of conditions as illnesses. Essentially, what the FDA did was it used the regulatory process it had at its disposal to regulate mifepristone, and the reason it used that process was to regulate it more closely than other drugs. So what's interesting about the opinion is that it hinges on this idea that the FDA misinterpreted how to apply this approval process and implying that it did so hastily or without regard to the evidence. But, I think there's really hard to refute evidence that the FDA took a long time to approve the drug, that it applied a process so that it could restrict the drug, frankly, in ways that are much more characteristic of drugs with much more risk.
Yeah, as you said, the FDA, rather than being careless, you're saying they were pretty intentional, but yet his decision, it had language that sounded like it was from the anti-abortion movement. Can you give me some examples?
Routinely refers to a fetus or potential life as an unborn human, people who provide abortion as abortionists, references abortion as a eugenic project, and then I think generally equating abortion with murder, equating abortion with depression, regret, and exploitation of what he says routinely women and girls.
The plaintiffs who brought this case actually are Tennessee-based, the Alliance for Hippocratic Medicine. Could you talk a little bit about this group? And if they're from Tennessee, why is this case in front of a Texas federal judge?
So I think that this group really formed to take this kind of case. The reason they're in front of the Texas court seems to be that they thought they would find a sympathetic audience. I think Kismarek has a track record that's pretty well known. Some notable judgments that he's had already from the bench suggest that he is open to arguments around judicial intervention and judicial action around certain issues.
Well, some people have referred to that as forum shopping or judge shopping. What does that mean?
So forum shopping is essentially, which plaintiffs can file in the court of their choosing. The plaintiffs have that right. And forum shopping is filing in a court where you think there is a track record by precedent, by cases decided, that would be favorable to the claims that you're pressing. There's been a lot of debate around a district court in Texas in which it seemed very friendly to people who were filing to claim patent infringement, so much so that it was becoming a kind of patent hub for the country. And that has, elicited a lot of comments about and a lot of commentary on the fairness of that. And what does it mean for a court to be kind of a funnel for a certain area of law because of the perception of litigants that that is going to be the best forum in which to file.
Well, let's go beyond Texas. There are 2 rulings about mifepristone and its legality floating around right now. On the same day as the judge ruled against the drug in Texas, a federal judge in Washington state ruled differently. Can you talk about that ruling?
So the Washington court, a federal district court with the same powers as the Texas court, granted in part the petition of 18 attorneys general that asked the court to essentially order the FDA to keep mifepristone on the market. So it's a preliminary injunction against the FDA from removing mifepristone's approval.
Do we know which takes precedence? Do we know at all?
They have equal power. One does not trump the other. They are, 2 similarly situated federal district judges. And so that, I think, is why we'll see this case probably go before the Supreme Court, because the Supreme Court often weighs in when there are 2 federal courts that disagree.
Well, since it seems that we might definitely go to the Supreme Court, do you have any thoughts on how this particular Supreme Court might rule in this particular case?
This is a really different case than, for instance, the Dobbs case, which overturned Roe and Casey, Roe v. Wade and Planned Parenthood versus Casey. That was about the nature and interpretation of the 14th Amendment and if it included this pre-viability right to abortion, which the court said it did not. And that's why we're here, is that it's now a matter of state law about what happens to abortion regulation. This is really different. At the heart of this case is a question about federal agency power. One court deferring to an agency because of its expertise and the overwhelming evidence about a drug. Another court refusing to defer to an agency's expertise and issuing its own judgment about whether or not a drug is safe. And so that is a question about abortion, but it's also a question about the nature of agency power and the deference agency expertise should be given.
We've also seen a response from the pharmaceutical industry itself. On Monday, senior executives from more than 250 companies, including ones people might know, like Pfizer and Biogen, sent a letter condemning the ruling, saying that it, quote, set a precedent for diminishing the FDA's authority over drug approvals, and in so doing, creates uncertainty for the entire biopharma industry. What does that mean?
It means that, pharmaceutical companies are rightly concerned about this judgment because they spend millions and millions and millions of dollars researching and developing drugs to ensure that they're safe, to go through the FDA process, to apply with the rigors of that process. And if a court can 23 years later say that none of that matters and the drug's not approved, it is going to upend the incentives and disincentives of research and development for pharmaceutical companies. Why would anyone invest all that time and money if they believe a judge in Texas can lift approval of the drug they've invested in some decades later?
And in a statement Friday evening, President Biden said, if this ruling were to stand, there will be virtually no prescription approved by the FDA that would be safe from these kinds of political, ideological attacks. Is this true?
One way to think about the decision is it's about medication abortion, and that's what it's about. But that's not how law works. This is a precedent that if it stands, other courts could cite to remove approval from another drug, with similar competing evidence of that drug's safety or efficacy or harms to the public.
So that statement isn't hyperbole.
I'm not sure it is.
After the break, what the FDA could do next.
This episode is brought to you by Saks.com. Saks.com editors are always tracking the top styles that are trending right now. Tailored blazers and midi dresses are selling out at Saks.com, especially from brands like Veronica Beard and The Row. And Saks.com editors are seeing Loewe's oversized tote on the streets of New York, Milan, and Paris. If you want your own free personalized trend recommendations, Saks.com stylists can do that and more. Plus, there's free shipping and returns all the time at Saks.com.
I'm Gideon Litchfield. I'm the editor-in-chief of Wired.
And I'm Lauren Good. I'm a senior writer at Wired.
We're making a new show.
It's called Have a Nice Future.
Have a nice future.
I like the way you say it. I'm more have a nice future? ?
It's a show that is honest about how unsettling the future can be. It's exciting, it's a little scary, but the message that we want to leave you with is that it is okay to be uncomfortable.
And this is an interview show, which means we're going to be bringing on the people shaping this future, the top technologists and thinkers and creators who we talk to all the time for our jobs.
We're going to ask them about living in this uncomfortable world, about the big challenges we face, about the challenges they're creating, the solutions they're proposing, and how they deal with living in perpetual uncertainty, as we all do.
So make sure you follow Have a Nice Future wherever you get your podcasts.
At the grand old age of 59, I hit rock bottom. So I went to Brooklyn, sat in a little tiny apartment in front of a panel of very serious coaches, and said, "Show me how I can do better."
The tone that you had was very similar to some of the students that I do work with. And that's what I teach them not to do. No offense.
Coming soon on Revisionist History. Listen wherever you get your podcasts.
Regardless of whether the order is ultimately overturned, there are a few different options for both the FDA and the future of medication abortion. Option 1. The FDA uses something called enforcement discretion.
The court did not order the FDA to do something, and the court, cannot order, I think, the FDA to do something. It just lifts approval without telling the FDA it has to withdraw approval from the drug or suspend it. Even if the order goes into effect and mifepristone's approval is temporarily suspended, there's still enforcement discretion, and the FDA can choose whether or not it enforces action against any manufacturer or distributor.
How would that work? What are some examples of products that the FDA has decided not to prioritize in its enforcement?
So one example would be infant formula. While there's been, approval pending or approval that hasn't been set, the FDA has allowed infant formula to be sold and used because of its assessment that the product is safe. And then there's just numerous examples about, the vitamins, supplements that we buy all the time that are not approved by the FDA necessarily, but are sold and consumed because there's very little safety risk.
Well, there's been a lot of publicity here, and everybody's been paying attention to it. What would the FDA have to do to reassure all the manufacturers and distributors that they can still offer mifepristone?
Yeah, so that's a great question. And, I don't know how that goes. The FDA could obviously issue a statement that it's going to apply its enforcement discretion. But the FDA could, communicate with Danco and GenBioPro. The manufacturers could communicate directly with the distributor that, about its intention and how it's interpreting the order. The FDA could also do and say nothing.
In other words, the FDA complies with the order, but it doesn't crack down on distributors or manufacturers. That's option 1. Option 2, The FDA ignores the order completely. This move has been floated by a few politicians, including Democratic Representative Alexandria Ocasio-Cortez and Republican Representative Nancy Mace.
So there's been a lot of conversation about the FDA ignoring the order. The FDA does not have to ignore any order. The FDA can comply with the order, but still use its statutory powers to grant enforcement discretion. I actually think it's dangerous to suggest that the agency just ignore a court order, even if that court order is crazy, because the FDA doesn't need to do that. The FDA can vigorously defend its authority in litigation and at the same time exercise enforcement discretion.
There's one more option. If the FDA cracks down, or if distributors and manufacturers stop producing mifepristone. Medication abortion involves two drugs. First, you take mifepristone, which blocks a hormone necessary for pregnancy. Then you take misoprostol, which causes contractions. Misoprostol alone is just as safe as mifepristone, but it leads to more side effects, including longer periods of bleeding, nausea, and cramping. It's been approved by the FDA, but only to treat ulcers, and it has fewer restrictions on it than mifepristone.
I think there are a lot of clinicians in the country that are ready to switch to misoprostol only, which is the second drug in a medication abortion. That can also terminate a pregnancy effectively in the first trimester. You don't need mifepristone at all. In fact, lots of countries across the world use misoprostol only. I think we might see a turn to that, which would be really interesting because misoprostol is not regulated by the FDA in any way like mifepristone. It is prescribed with mifepristone, and that's been the gold standard of medication abortion. To be clear, misoprostol is effective and safe early in pregnancy, but it's not quite as effective as the two-drug regimen. The irony is that if clinicians switch to misoprostol only, medication abortion, because of this judgment, it might become more available because there are no restrictions on misoprostol. Any provider within their medical expertise or practice can prescribe misoprostol. Mifepristone can only be prescribed by certified providers. There are not the same informed consent forms, a patient agreement form. That, I think, is an interesting potential consequence.
Do you have any thoughts on what should the FDA's next move be?
I worry that a statement by the FDA about exercising its enforcement discretion will be interpreted and taken up as, the FDA is ignoring the law. And that's, I think, something that the FDA would be worried about, people misinterpreting its intent. But, I think the FDA, if it could clearly communicate the nature of this power and its ability to apply it and the effects of doing so, those reassurances could be helpful.
One issue I see with the strategy you laid out is that pharmaceutical companies and corporations in general are very risk averse. Have you considered that companies are too worried about legal challenges and all the publicity this has gotten to continue the status quo with mifepristone?
Definitely. I think, and there's reasons to be risk averse because companies like providers are worried about being targeted by anti-abortion groups who, would seek to sue or bring claims against them. So I think that even with an announcement that the FDA is not going to pursue actions against distributors or manufacturers, there's reason to think that some companies will say, we want the approval of the FDA. We don't want to be on the wrong side of an approval process. We are risk averse. I certainly think that's a possibility.
This drug, mifepristone, has been on the market for more than 2 decades, as we talked about. And this is the first time a judge has ever invalidated approval of a drug that's been on the market for so long with such a track record. What could this mean for the future of the FDA's authority in the United States?
Certainly for the FDA, it's a case in which a court could say that the FDA's 20-year reliance on evidence and studies and research in one of the most studied drugs on the planet is just wrong, and based on that court's own evidence. And that really does undermine the FDA.
What about the future of medication abortion itself?
It is part and parcel of the attacks that we're going to see year after year in this country. I think the ground zero of the abortion war that's to come, that's here, is about medication abortion.
Thank you, Rachel Rebouché, for coming on What Next?
Thank you for having me.
Rachel Rebouché is the Dean of the Temple University Beasley School of Law. That's the show. If you're a fan of What Next, the best way to support our work is to join Slate Plus. Go to slate.com/whatnextplus to sign up. What Next is produced by Elena Schwartz, Anna Phillips, Paige Osborne, and Madeline Ducharme. We're getting help from Laura Spencer. We're led by Alicia Montgomery, with a little help from Susan Matthews. Ben Richmond is the Senior Director of Podcast Operations here at Slate. And I'm Mary C. Curtis, columnist at Roll Call and host of its Equal Time podcast. Find me on Twitter. I'm at mcurtisnc3. I'm handing things off to Lizzie O'Leary and the What Next TBD crew. Thanks for listening. Talk to you soon.